visiting our court and country more often.
Thank you.
Yes, Mr. Jethmalani.
My Lord, I was reading paragraph
I was wondering,
237.
instead of reading the 17-page note, why don't you formulate what the essential points are?
Yes.
Yeah, so that then we can,
Yes.
we know where you stand.
But at the end of each, I was going to make my proposition. At the end of each. So I just finished
Jethmalani,
this.
why don't you formulate what you have to say, so that we'll read the note. There's no difficulty about it.
Yes. May I just finish reading 237 and 238, or it's not? Your lordships are familiar with it.
We've already read that judgment.
All right.
Continue from your note.
I'll read.
Or if you can formulate what your submissions are, isn't that? That may be better. If you can.
So as I said, my submission on this aspect of the matter, first, of course, it's not necessary to go into any revisit of the judgment in Nabam Rabia. But the lordships do want to revisit it. It should be for reaffirming the view enunciated, in particular by the decision of Justice Mishra, which is that he's disabled. A speaker or a deputy speaker is disabled for his functions as a speaker at the time of a notice to remove him, and not at a subsequent stage when that notice is under consideration.
Yes.
Now, so that view, my lord, sir, I'm now reading page 6 of my note, is fortified by the following submissions. The fact that a prior notice of 14 days is to be given. Has your lordship's got that, my lord? I'm at page 6 of my note. Presents every opportunity to those aggrieved by the said notice to thwart the intention of the notice. A speaker or a deputy speaker whose removal is intended will be tempted to take all steps available to him to dissuade or prevent the mover of the motion from proceeding with it further in that 14-day period. So that 14-day period provides him an opportunity which not only is capable of being misused, it had been misused, and I showed that particularly with reference to the facts of the instant case. And that's my second proposition, that subsequent events revealing gross misconduct and partisanship on the part of the deputy speaker, as more particularly set out here, and I'll come to those, during the 14-day notice period, vindicate the view in Nabam Rabia regarding the period when the deputy speaker's or speaker disability under Article 181 commences. Then third, now, Lord, Article 181 deals with a situation where the resolution for the removal of the speaker is under consideration and prescribes the restrictions on the speaker or deputy speaker that at a sitting, that article is concerned with a sitting of the Legislative Assembly. Please note that, my lord.
Yes.
At a sitting of the Legislative Assembly, when such resolution is under consideration, then the deputy speaker or the speaker, as the case may be, shall exercise all the powers available to a member of the Legislative Assembly, but not those that pertain to the office of speaker stroke deputy speaker. Now, my lord, this is logical. I'm sorry.
Yes.
This is logical as the notice for removal is from the office of speaker, deputy speaker, and not as a member of the Legislative Assembly. While Article 181 uses the word any resolution and not notice of intention for removal of the speaker, that is because while consideration of the resolution has to be during the sitting of the Assembly, or it can only be when the House is in session, a notice of intention can be given even when the Assembly is not sitting. So Article 181 itself does not prohibit a construction that a deputy speaker cannot act as such deputy speaker from the time a 179C notice is moved. 181 deals with a sitting for consideration of the Legislative Assembly. And one of the rules between 179C and 181, that is notice given and then 181, consideration of the notice, there is a vacuum. That vacuum is filled up by Rule 11. The House itself has made rules as to what will happen in that interregnum. But if the Lordships want, I'll read it very quickly. Rule 11.
That's all right.
Not
We've seen the rule.
We have seen rule 11.
So that in short, but not that he has to give a notice 14 days period, and then as soon as may be. But the House rules make it almost impossible for there to be any serious delay in the matter pertaining to disposal of this issue of his removal. Because it's only that 14-day period. Immediately after the 14-day period, he has to refer it to the House. And then, so basically it's 14 days. And
so according to the prohibition, the period when the speaker is barred from considering a petition for disqualification commences the moment a notice is given.
Yes.
Commences the moment a notice is given.
And any misuse is circumscribed by the rules of the House, which say immediately after the 14 days almost, you must put it up to the House. If you get 29 members, it will then be considered. You don't get 29 members after 14 days, the issue is dead and then.
All right. What is the next point now?
Then the provisions of Article 181 of the Constitution are based upon the rule against one being a judge in one's own cause. In other words, the nemo judex in cause sua rule. There is no reason why this rule should be restricted to the case of consideration of resolution, but not at the stage of notice, when a speaker who continues to function as a speaker can use his powers as a speaker to alter the constituency that will decide on his removal. So he can gerrymander the constituency that decides on whether he should, if he's allowed to remove them. And that's the whole purpose of. Now, the Lordship will kindly have, what is it that is prevented by 179 or 181? It is that the Speaker cannot preside. He cannot preside over the House. That word is important. By presiding over the House, he gets several powers, which can, my lord, and his powers, at least under our constitution, are almost paramount. They're unchecked. His is the last word. Regarding procedure in the House and decisions taken, his is the final word. There's no check on it within the House. It's only governed by the rules. That's it. Now, my lord, your lordship, may quickly see two rules which have not been pointed out so far. Rules 53 and 58 of the Maharashtra Assembly Rules, PDF 34 and compilation 3C.
Read the PDF page.
PDF 34. I know that it is the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The Speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the House are suspended when his motion is under consideration for his removal. Now, my lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well not scuttle the entire removal procedure. And I'll briefly remind your lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my lords, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds. This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd June 2022, Sunil Prabhu, acting as Chief Whip of the Shiv Sena Legislature Party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri Eknath Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the Chief Whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF, page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. For that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule. For what? For not attending the meeting. Now, my lord, the contention of the petitioner is that the notices issued on 21st and 22nd were validly issued and were binding on all members of the Legislative Assembly. Our contention that the two resolutions of 21st and 22nd were illegal for the following reasons. Prabhu had been removed as the party whip by 34 MLAs of the Eknath Shinde group on 21st June itself. After he had been removed, he issued that notice or notices. The notices were therefore without jurisdiction. Now, very important. Moreover, it is well settled that a party whip can only be issued for actions on the floor of the assembly and not outside the house. The party whips of 21st and 22nd June were misconceived and illegal insofar as their content was concerned. Now, my lord, over here, there's a new document which is not before your lordship, but we have filed it just now regarding the Legislative Assembly debates, the parliamentary debates pertaining to the 52nd Amendment in 1985. I'll just read the speech of one member.